Good afternoon, everybody. I'm David Levy, Dean of the Duke Law School. Welcome to the Brainerd Currie Memorial Lecture. This lecture series is named in honor of Professor Brainerd Currie, who taught contracts, admiralty, and conflict of laws at Duke in the 1940s and then again in the 1960s. He was an admired scholar, and he was a beloved teacher here at Duke, as well as at several other law schools, including the University of Pittsburgh, where he was the dean, and at the University of Chicago. Professor Currie was a preeminent theorist on the conflict of laws. He was also a gifted teacher. One of Professor Currie's students wrote after his death that ideas were the essence of his classroom hour. It is fitting, then, that Duke has seen fit to honor him for so many years with this distinguished lecture series. The series began in 1967, and if you look at the list of scholars who have given the lecture, it's truly a remarkable group of people, scholars of the first rank. And this year is no exception. Our lecturer is Professor Mark Tushnet, the William Nelson Cromwell Professor of Law at Harvard Law School. Our own Professor Christopher Schrader will introduce Professor Tushnet. Professor Schrader is the Charles S. Murphy Professor of Law and Public Policy Studies here at Duke Law School. He is one of the directors of our program in public law, and he's co-founder of our Duke in D.C. program. He is also President Obama's nominee to serve as the Assistant Attorney General for the Office of Legal Policy at the Department of Justice. He's had a distinguished career in government. He's an eminent scholar in the constitutional structure and in environmental law. Professor Schrader.
Thank you, Dean Levy. I'm delighted to introduce Mark Tushnet as our Brainerd Currie lecturer this year. Mark is one of the most distinguished, wide-ranging, and prolific scholars in the American Legal Academy. He clerked for Justice Thurgood Marshall, later became Justice Marshall's biographer, wrote a two-volume set of books, one about Justice Marshall's career as an advocate and the other about his career on the court. He has also written two volumes on the history of the civil rights movement and its legal strategy. His book-length writings also include important contributions to constitutional theory and interpretation, as well as to the dissection of particular doctrinal controversies. He has written on topics that range across the Second Amendment, the death penalty, abortion, the Bill of Rights, the development and current practice of judicial review, popular constitutionalism, the nature of constitutionalism and constitutional law in times of emergency, on the Rehnquist Court, and on the American law of slavery. And that's just a partial list of his book-length contributions. I haven't touched on his writings that appear in law reviews or in book chapters, and it's just as well that I don't. In 2001, writing in a symposium honoring Mark's work, his longtime colleague, collaborator, and friend Lou Seidman calculated that Mark was author of some 242 articles and book reviews, in addition to 40 books and book chapters, and that was 2001. But rather than have me stay up here longer singing his praises, I just want to take a second to let Jack Bulkin and Sandy Levinson do so. Writing in that same symposium, these two, themselves distinguished American legal scholars, wrote, "Mark has been a central, we would say seminal, figure in constitutional law, in legal theory, and in legal history. If he had never written a word about constitutional law, he would still be honored for his contributions to legal history, first as an historian of the law of slavery, and later an historian of the civil rights movement. If he had never written a word about legal history, he would still be renowned for the stream of articles and books of the highest quality he has produced on virtually every facet of constitutional theory and constitutional doctrine. Finally, even putting his status in these fields to one side, he remains a central figure in the creation and development of one of the most important 20th century jurisprudential movements, critical legal studies." Mark's speaking to us today and taking a piece out of a larger project upon which he is working I'm not going to say anything about that, not so as to avoid stepping on his lines, but I'm sure he will tell us something about the larger project in the course of delivering today's lecture. So would you join me in welcoming Professor Tushnet?
Thank you for that very nice introduction. I'm very pleased and honored to be giving the Currie lecture today, not only because of the distinction of the series, but because I am able to perpetuate the two generations of law professors that were associated with the Currie family. My daughter is a law professor as well, so Brainerd and David Currie, me and Rebecca Tushnet, and we're carrying on. It's not clear where our grandkids are going to go, but they're a little young so far. The work that I'm going to present is the first product of a long-term project on the history of the Supreme Court, basically in the 1930s under Chief Justice Charles Evan Hughes. This volume, when or if it's completed, will be part of the Oliver Wendell Holmes devised History of the Supreme Court. I've been working on it for, I think now 3 years, and I have 4 or 5 more to go, which is why the conditional is in my formulation. When I accepted the contract, my wife said, you know, people die before they finish these volumes, and it's true. So we're a little nervous about it, but I'm working away. I wanted to open with just 2 comments, one about the methodology of the work, including what I'll be presenting today, and secondly, a description of the general argument of the book taken as a whole. The methodological point is an important one. The way I put it is that if it didn't happen, or if it happened after 1941, it didn't happen. That is, I want to capture the sense of the law at the Supreme Court as it appeared at the time. So in particular, in 1933 or 34, the justices and observers didn't know that the constitutional revolution of 1937 was around the corner. The sort of the deep methodological point here is captured in the Monty Python line, nobody expects the Spanish Inquisition. Right? Who knew that the Spanish, similarly, who knew 1937 was going to happen? And then second, the general argument of the book is that in a whole range of areas, the progressives, who I'll be talking about in some detail today, had developed an extremely vibrant and intellectually coherent criticism of the law that they were addressing, of the pre-1937 law, but they actually had no really coherent alternative to offer. Really good criticisms and then sort of a blank. So when they took over after 1937, they actually didn't know what to do. That's not quite the story in administrative law, but it's related. And the relation is this. The progressives strove for what Roscoe Pound, near the end of the decade, called administrative absolutism, which I'll describe in a moment. They couldn't achieve it in the Supreme Court. And in fact, as I hope to be able to show, the progressives lost every major administrative law case in the 1930s. And not surprisingly, they treated each decision as a major defeat. But that's because they were asking for so much. They sought administrative absolutism. They sought 100%. They got 70 or 80%, and they treated that as a loss, which in some sense it was. But what they got was much more than half a loaf. 70 to 80% is more than nothing that they presented it as being. So what I'm going to do is begin by describing administrative absolutism as presented by the progressive theorists of administrative law, and then turn to some of the major Supreme Court cases on administrative law that occurred in the 1930s, I should say here, I am talking about administrative law in the modern sense, the sort of, I'm not, there are a series of cases related to the administrative bureaucracy, such as Humphrey's Executor or the non-delegation cases, which I treat in a different chapter of the work as constitutional cases. Here I want to talk about administrative law as such rather than its constitutional aspects. Much the same was happening in the constitutional cases as what I describe here. In 1939, at the end of the decade, James Landis, a Harvard law professor, New Dealer, dean at Harvard, gave the Storrs Lectures at Yale on the administrative process, in which he recounted the progressive story of administrative law as a prelude to his reflections on administrative law after the New Deal. The story began, and this is a consensus story among progressives. Landis gives it. I'll actually give you another version of it from another progressive theorist in a few minutes to emphasize how widely shared this was. The story that Landis told began early in the 19th century when, as he put it, the functions of government were limited essentially to the prevention of disorder, protection from foreign invasion, the enlargement of national boundaries, the stimulation of international trade, and the creation of a scheme of officials to settle disputes. Industrialism and the rise of democracy, he said, caused social maladjustments which required rectification. At first, legislatures tried to regulate directly, enacting statutes addressing particular difficulties, but these statutes were crude and useless. Common law remedies administered in the courts were not much better. Depending on the initiative of aggrieved parties or public prosecutors, those remedies were more apparent than real because of the costly and uncertain character of the legal actions that had to be pursued. The adjustments that were needed, Landis wrote, could not be achieved through intermittent intervention of the judicial process. Or, as another student of administrative law put it, the inadequacy of the common law processes and the shortcomings of direct statutory regulation produced the modern administrative agency. The administrative process, in Landis's words, is in essence our generation's answer to the inadequacy of the judicial and legislative processes. According to Landis and the progressive understanding, the administrative process springs from the inadequacy of a simple tripartite form of government into legislature, executive, and courts to deal with modern problems. Administrative agencies could provide a continuing concern with and control over the economic forces which affect the life of the community. Dynamic social change regularly produced novel problems. Legislative intervention was always too late, addressing problems that often had faded into insignificance by the time the legislatures acted, to be replaced by new problems requiring new solutions. The courts asserted control only sporadically, leaving too much in the way of enforcement of claims and interests to private initiative, and so were unable to maintain a long time uninterrupted interest in a relatively narrow and carefully defined area of economic and social activity. Now, you can see where this goes. Expertness, Landis wrote, springs only from that continuity of interest, that ability and desire to devote 52 weeks a year, year after year, to a particular problem. The art of regulating an industry requires knowledge of the details of its operation, ability to adjust requirements as the condition of the industry may dictate, the pursuit of energetic measures upon the appearance of an emergency, and the power through enforcement to realize conclusions as to policy. Now, progressives gradually, grudgingly accommodated the courts in the early years of modern administrative law, facing courts suspicious of the substantive policies the new administrative agencies were told to pursue, and lawyers determined to retain lucrative business. The agencies responded by giving their procedures a judicial form, hearings at which evidence was taken, limitations on the use of hearsay evidence and the like. In Landis's words, the expertness of the administrative, if guarded by adequate procedures, can be trusted. The progressives were willing to go part of the way towards procedures, resembling those in judicial proceedings. But their concessions were never enthusiastic, and progressive defenders of the modern administrative state regularly attempted to limit efforts to impose a judicial form on the administrative process, and did what they could to retrieve ground that they had had to give up during the early years of the administrative state. So Landis wrote, the tendency over the past few decades has been to decrease rather than to increase the power of judges to impose checks upon the exercise of administrative power. The progressives wanted to insulate the modern administrative state from judges supervising the agencies and imposing court-like procedures on them, and from lawyers who lacked the comprehensive overview of the economic or social problems within each agency's jurisdictions. Landis was writing in 1939. Felix Frankfurter had given the Storrs lectures in 1930 called The Public and Its Problems, Public and Its Governance. In those lectures, Frankfurter, with a progressive confidence that merely exposing difficulties in government would lead to reform, called not for a reimagining of how administrative agencies could operate in the workaday world, but for reinvigorating the progressive ideal. The complex problems of regulation, he said, call for a governmental agency qualified by experience, fortified by technical assistance, free from the pulls and pressures of politics, generating an esteem in the public such as the public now entertains for the judiciary, a public esteem which in its turn will arouse in these officials enterprise, courage, and devotion to the public good. One of Frankfurter's students had expressed his own skepticism about staffing administrative agencies, but Frankfurter was undeterred. I want to now turn to some work by one of Frankfurter's students, I.L. Scharfman, who wrote a book, or 4 volumes, a comprehensive overview of the Interstate Commerce Commission from 1887 to the 1930s, filled or padded with long excerpts from commission decisions and reports and from Supreme Court opinions. On its opening pages, the work stated the progressive explanation for the rise in value of administrative agencies. The very existence of an expert and continuously functioning body has facilitated the evolution of governmental policies responsive to public needs and realistically adjusted to meet those needs. The Commission had ample opportunity to adjust administrative holdings to the varying demands of changing conditions. The approach has been pragmatic. The method of trial and error has been controlling. Scharfman repeated the argument that judicial and legislative regulation had failed because the demands on the agencies on government was too great. Scharfman's enthusiasm for administrative agencies gave him strong views about other organs of government. At this point, you'll be able to see the emergence of the idea of administrative absolutism. For him, all that Congress, the executive branch, and the courts could do was interfere with the agency's use of science and expertise. Congress had one positive role. It could create an administrative agency and then delegate authority to it in the broadest terms. Although I actually think that from Scharfman's point of view, analytically, if somehow agencies could be brought into existence by immaculate conception, that would be even better. Scharfman understood that the very existence and jurisdictional scope of these agencies is dependent upon and subject to modification by statutory enactment, but these standards are usually couched in such generality of terms as to leave open an almost uncharted discretion in the disposal of specific proceedings. He used the example of the Commission's power to determine whether rates were just and reasonable and in the public interest. Within the bounds of such vaguely defined ends, the Commission exercises virtually unrestricted authority. And that, for Scharfman, was all to the good. Otherwise, Congress had only negative effects on the administrative process. Prodded by narrow interest groups who lacked the comprehensive overview the agency had, Congress would direct the agency to solve some quite isolated problems. The agency's expertise often didn't extend to the problem turned over to it, and even when the problem was generically appropriate for the agency addressing it would undermine its comprehensive plan for the railroad industry. The presidency was no better. Presidents tried to mold the general course or direction of regulatory policy through manipulation of the appointing power, Scharfman said. Presidents assumed that the commission is part of a national administration and hence is a proper medium for the expression of political policy. But it was not, no more than was the Supreme Court. And executive influence is as manifestly out of place in the one case as it would be in the other. Presidents should appoint experts to the agencies, but too often they allowed narrow political considerations, geography being the most important one for the ICC, to dictate choice. Finally, the courts too should be kept away from the administrative agency. They saw the commission's work only when someone brought an appeal challenging an agency decision and then therefore didn't see how an agency was operating overall or how a particular decision, which might to an outsider seem questionable, fit into a larger scheme the commission had developed. The early commission was hindered by the open hostility of the railroads, Scharfman wrote, and the unsympathetic attitudes of the courts. When the courts used broad powers in the agency's first years, the prestige and effectiveness of that body were seriously jeopardized. He characterized the Supreme Court decision in 1914 as one that effectively destroyed the entire fabric built up by the commission. Fortunately, the era in which the courts were deeply hostile to agencies had passed, and they had come to accept agencies as valuable instruments of modern governance through a self-denying interpretation of their own functions in the prevailing scheme of control, Scharfman said. The courts have progressively narrowed the scope of judicial review. Constitutional doctrine was far more generous to the commission than it had been in the agency's early years, though not in Scharfman's eyes quite generous enough. Judicial review, he said, of the legitimate exercise of discretion would relegate the method of administrative control to a subordinate status and would defeat the very purposes for which the commission's vast grants of flexible authority were conferred. Thankfully for Scharfman, the courts have adopted a dominantly self-denying attitude in matters of review, although he couldn't resist observing that this was not characteristic of the commission's status during the first 2 decades of its existence. When the courts looked at agency procedures, their sporadic interventions were rarely helpful, and Scharfman commended the commission for going to Congress for relief when judicial decisions have less serious gaps in the commission's functioning jurisdiction. So that's the picture that the progressives shared, the ideal of administrative law. Agencies were staffed by experts who were deploying technological or technocratic expertise, and interventions by any of the other branches, Congress, the presidency, the courts, were likely to be disruptive of the agency's functions. I should note Landis in his lectures was unabashed about describing the agencies as a fourth branch of government. As my formulation just suggests, he has a line which I think is quite powerful, that somehow people think that there's something magical about the number 3 rather than 4 or 5. And that was the vision that the progressives had. Now, the Supreme Court weighed in on administrative law in a series of cases during the 1930s, both before and after New Deal legislation created an efflorescence of new agencies, the Securities and Exchange Commission, the National Labor Relations Board, and others. As the 1930s proceeded, again, both before and after the New Deal, constitutional and administrative law moved more haltingly than Frankfurter and other progressives hoped, but farther than they acknowledged toward the progressive ideal. Frankfurter and other progressives, including dissenting justices, saw the court's decisions as a mix of persistent resistance to the modes of governance required by modern society, with grudging but quite modest accommodations of traditional doctrine to new problems. Yet the progressive agenda for administrative law was, in essence, to liberate agencies from judicial supervision so that technocracy guided loosely by politics could replace law. Nothing the court could do other than withdraw completely from the field would have comported with that agenda. The Hughes Court's decisions in administrative law transformed administrative law without going that far. They greatly expanded the boundaries within which administrative agencies, again, the characteristic governing form of the modern bureaucratic state, could operate free of significant judicial supervision, although the true breadth of the Hughes Court's concessions to those agencies wouldn't be apparent until the 1940s, after Hughes had passed from the scene. As in much of the Hughes Court work, the court moved into the terrain Roosevelt appointees hoped the court would occupy, but left them unsure about exactly where they were. What I want to do now is turn to some of the Supreme Court cases. I'll see how many I can get through in the time available to illustrate what the court did and how it gave the progressives more than half a loaf of what they were seeking. The Hughes Court was operating against a background of administrative law that by the 1920s had stabilized. Although there was no general administrative law, no Administrative Procedure Act, but merely statutes dealing with individual agencies or a general law dealing with judicial review of executive action, lawyers understood the patterns that had emerged. Agencies could indeed depart from traditional judicial procedures, and across a rather wide range of matters, courts would accept their decisions. The open questions involved determining the limitations of departures from the conclusiveness of agency decisions. Progressives affirmed the principle. Some of the cases involve substantive review, others involved procedural review. The progressives affirmed the principle of expertise even with respect to procedure. They argued that within the broad constraints of fundamental fairness imposed by the due process clauses, agencies should be allowed to adopt whatever procedures they thought appropriate to matters within their jurisdiction, and a court should not import their own conceptions of procedural nicety into those procedures, but should defer to the agencies. The proliferation of agencies in the New Deal placed this accommodation under substantial pressure, the 1920s accommodation. In part, the pressure arose from what became obvious, that some aspects of agency decision-making didn't involve anything that could have been classified as scientific expertise in traditional terms, and concomitantly that some aspects of agency decision-making were political in a straightforward sense. The National Labor Relations Board was the sort of key example here. As a whole, the NLRB was an obviously politicized body whose claims to expertise were regularly belied by its decision and by the evident partiality of its staff, including the lawyers on its staff. The ICC, the object of Scharfman's and Frankfurter's admiration, may have set the gold standard for administrative agencies, but elite lawyers, including a majority of the Supreme Court, understood that not every agency measured up to that standard. Progressive claims about the inherent fairness of decisions made by independent and expert agencies rang hollow, or at least hollow enough to threaten to undo the accommodations reached in the prior decades. The Hughes Court struggled to develop an administrative law that accommodated the varied performances of the agencies it supervised. The progressives' theory remained what it had been from the outset. In principle, agencies should have complete discretion to choose the procedures to be determined by experts in the field to be suitable to the problems facing each agency. I think I want to, the problems that this vision confronted were posed by images coming from across the Atlantic. In the 1880s, the British legal theorist A.V. Dicey said that the only way to justify administrative agencies was to make them essentially court-like or subject them to complete review in, as Dicey put it, the ordinary courts. That was one specter in the background. The U.S. law departed from the Diceyan vision. But what Dicey was concerned about was an administrative state completely divorced from democratic control. By the early 1930s, there was another specter from across the Atlantic, Soviet Russia and Fascist Italy. They had replaced bureaucratic France as the image of the administrative state degenerating into tyranny. Soviet Russia and Fascist Italy were to be joined in the next few years by Nazi Germany. Defending democracy as the reign of reason on the most extensive scale, Frankfurter observed in 1930 that sensational and violent rule in Russia and Italy throws out of perspective more plodding popular institutions. How, though, were those plodding institutions to be truly popular if they were staffed by professionals and experts? To some extent, the progressive theorists of the administrative state simply asserted that the norms of the professions of which the experts were members were enough to give popular sanction to the technical exercises in which the professionals were engaged. In Landis's words, a professionalism of spirit, an attitude that perhaps more than rules affords assurance of informed judgments. Frankfurter said the quiet, detached, laborious task of disentangling fact from fiction, of extracting reliable information from interested parties, of agreeing on what is proof and what is surmise must proceed if agitation is to feed on knowledge and reality. But in the same passage, Frankfurter acknowledged that one of the patent facts about our system was that the level of professionalism of trained capacity is very low. And Landis extended his observation beyond the administrative justice, the administrative state generally. Improving the personnel of administrative agencies might be desirable, Landis said, but until it was accomplished, agencies might lack sufficient democratic justification. So what could you do? Walter Gellhorn, writing in 1941, said the very procedures designed to ensure fairness to the subjects of regulation also democratized our governmental processes because they bring to the interests and individuals immediately affected an opportunity to shape the course of regulation, modeling it to fit the contours of their own special problems. Gellhorn is beginning to articulate a more pluralist vision of administrative law that was not fully realized as a theory until after 1941. Now let me turn to the Supreme Court cases. The first major dust-up over the New Deal approach to administrative law occurred in 1936, concurrent with what the New Dealers saw as the court's attack on the New Deal itself, and that had some effects on the way they saw the case. The St. Joseph Stockyards case, it involved an ordinary rate-making proceeding dealing with the setting of the salaries or fees for certain so-called commission men at the stockyards in St. Joseph. In 1931, the regulators issued an order requiring a reduction in the rates. And the question on review was what the standard of review or the scope of review should be. Did the court have to accept the Secretary of Agriculture, the relevant decision makers' findings of fact if they are supported by substantial evidence, or was the stockyard entitled to the independent judgment of the court? Before the Supreme Court, both sides saw this scope of review question as key. Hughes wrote the majority opinion. For him, the scope of review issue was directly connected to the Constitution's supremacy. Sounding a realistic note, he observed that agencies work in a field peculiarly exposed to political demands. Some may be expert and impartial, others subservient. making agency findings conclusive where constitutional rights of liberty and property are involved is to place those rights at the mercy of administrative officials. For Hughes, that prospect with our multiplication of administrative agencies is not one to be lightly regarded. Although Hughes didn't spell it out, the connection between these concerns and his earlier references to political demands and subservient agencies is clear. Independent judgment on facts bearing on constitutional rights was necessary to guard against the possibility that a subservient agency would twist its factual findings in response to political demands. But this didn't mean that courts should simply disregard what the agency had done. The court's task, in Hughes' words, may be greatly facilitated and informed and aided by the sifting procedure of an expert legislative agency. The courts were to look at the record as a whole. There was a strong presumption in favor of the conclusions reached by an experienced administrative body after a full hearing, and the regulated entity had to make a convincing showing that rates were so low as to amount to confiscation. Summarizing, Hughes wrote, "Findings made by a legislative agency after hearing will not be disturbed save as in particular instances they are plainly shown to be overborne." Hughes rejected the most extreme position he thought the government might be taking, that agency findings of fact had to be accepted by the courts if those findings were supported by any evidence at all. In form, he rejected the proposition that such findings had to be accepted if they were supported by substantial evidence. Yet he followed his rejection of that proposition with statement after statement indicating the courts would be well advised to give substantial weight to the agency's findings, not treat them as binding if supported by substantial evidence, but give them substantial weight. Notably, the entire controversy involved only findings of fact bearing on the question of whether the agency action violated the Constitution. That the substantial evidence test applied to other agency findings was accepted by all. Now, this analysis looked backwards to a legal world in which, as Brandeis dissenting put it, rigid rules governed in an on and off fashion. Independent judgment on facts bearing on constitutional violations, substantial evidence for other facts. Brandeis took a non-formalistic approach in which the interests were to be balanced. That allowed him to distinguish among constitutional rights, foreshadowing one of the approaches the court's progressives took after 1937. But Hughes's opinion had its realistic elements as well. Even the progressive theorists of administrative law understood that what Hughes described as the multiplication of administrative agencies undermined the progressive claim that all agencies were equally expert. Brandeis, again dissenting, envisioned a world where administrative agencies were professional and expert and relied on a seemingly infallible judiciary to take variations in expertise and ability into account when balancing interests. Hughes explicitly recognized imperfections in agencies, and his formalism implicitly recognized the difficulty imperfect judges would have in accurately determining which agencies deserve greater deference, which less. Imperfect courts exercising independent judgment in all cases might produce a better accommodation of competing interests than imperfect courts attempting to balance the interests directly. Under Hughes's approach, the courts nominally exercised independent judgments, but giving weight to an agency's finding is not the same as treating those findings as conclusive if supported by substantial evidence. But the difference isn't large. Another New Dealer thought that the mental gymnastics required by Hughes's formulation were beyond the capacity of even the greatest human intellect. If so, the decision would be a victory in practice for the progressive conception of administrative law. For Hughes, though, leaving the decision in the court's hands, no matter how little they might matter in any case, preserved what was left of the Diceian tradition in U.S. administrative law. As he did in so much of his work, Hughes looked backward and forward at the same time. The second case I want to discuss was widely noted then as disappeared now, a case involving a guy named J. Edward Jones, who was a flamboyant chair of the National Petroleum Council, which purported to represent independent oil producers. He was a fervent opponent of government regulation of his business practices. And depending on how you read the evidence, he comes across sort of as maybe like his era's Bernie Madoff, except he was charged with but never found liable for operating a Ponzi scheme. The SEC thought he was operating a Ponzi scheme, but they never approved it. And he may have been just a very aggressive businessman. It's not clear. But he was a very aggressive businessman. He mounted an overall constitutional challenge to the SEC when the SEC proceeded against him in sort of peculiar circumstances. He filed a registration statement for a new offering of rights to participate in the distribution of oil royalties. That was how he operated. The SEC told Jones that it proposed to direct him to stop offering the new rights, saying that his registration statement appeared to contain untrue statements, to omit other facts that investors would find important. He had basically 20 days to do something about it, to respond to what they said. The day that it was to become effective, Jones withdrew his registration statement. The SEC took the position that that withdrawal was ineffective and continued to proceed against him. The case came before the Supreme Court as a combination of a technical challenge to whether he could withdraw the statement and a comprehensive constitutional challenge to the Securities and Exchange Act. After the oral argument, Landis wrote Frankfurter that the only possibility of defeat is on a procedural point, which turned out to be accurate, and that he could not see a sane bench of judges not giving us some freedom in working out our procedural technique. That turned out not to be accurate. At this point, Landis was chair of the SEC. A six-justice majority held that Jones had an absolute right to withdraw his registration statement before it came effective. An opinion by George Sutherland. Sutherland noted that the statute had no provision dealing with withdrawal without guidance from the statute. He turned to judicial practice. The settled rule, he said, was that plaintiffs had an unqualified right to dismiss a complaint unless doing so would harm the defendant. The SEC's regulation was to Sutherland the same as the judicial rule, and all of that was largely unexceptionable. You could disagree with it, but analytically it was nothing special. And then Sutherland escalated the rhetoric. The action of the commission, he wrote, finds no support in right principle or in law. It is wholly unreasonable and arbitrary. To the precise extent that the mere will of an official or an official body is permitted to take place of allowable official discretion or to supplant the standing law as a rule of human conduct, the government ceases to be one of laws and becomes an autocracy. He continued, arbitrary power and the rule of the Constitution cannot both exist. Accepting the progressive account of modern government, Sutherland described agencies as necessarily called into existence by the increasing complexities of our modern business and political affairs, and said that they could not be permitted gradually to extend their powers by encroachment, even petty encroachment, upon the fundamental rights, privileges, immunities of the people. Otherwise, we shall, in the end, while avoiding the fatal consequences of a supreme autocracy, become submerged in a multitude of minor invasions of personal rights, less destructive but no less violative of constitutional guarantees. There's a libertarian strain in the conservative position that Sutherland articulated here and in other cases, and it clearly affected Sutherland's position in this case, and it had some merit, but he went too far in linking the SEC's inquiry to, as he put it, the intolerable abuses of the Star Chamber, and insisting that even the shortest step in the direction of curtailing the rights against unlawful inquisitorial investigations must be halted in limine unless it serve as a precedent for further advances in the same direction. Somehow, Sutherland discerned in the government's position the philosophy that constitutional limitations and I'm missing something here. Well, it doesn't really matter. I've said enough in describing Jones. It was of a piece with St. Joseph's Stockyards. The majorities in both cases were to some degree skeptical about the fairness of proceedings before some administrative agencies and sought refuge in general and formalistic rules that would constrain imperfect agencies while accepting the fact that the rules would also interfere with the smooth operation of well-functioning ones. That was the import of Hughes's reference to subservient agencies and of Sutherland's insistence that incursions on rights had to be stopped at their seemingly mild outset. The dissents in both cases were confident that courts could stick close to the practicalities of government as revealed by history, and that they, that is, judges, could accurately apply pragmatic tests of workability in an imperfect world. Their confidence in the courts led them to place a lower value than the majority did on the possibility, the majorities would have said the fact, that some agencies would sometimes go off the rails. The SEC's chair, Landis, issued a statement saying that the Jones decisions would put some difficulties in the way of labeling fraudulent promoters as such, but the commission's work would go on because most of the agency's investigations involved registrations that had taken effect. The Wall Street Journal, which was a supporter of the Securities and Exchange Commission, it's important to note that for a contemporary audience, were a little disturbed by the Jones decision. The decision left no casualties, as their editorial was titled, "Nothing in the decision seriously impairs the usefulness of the SEC, because the decision at most admonishes the SEC that it does not possess a specific power. No part of the very great amount of excellent work the SEC has done was based upon its power to continue an investigation after a registration had been withdrawn." The editorial reassured its reader that public securities offerings remain as fully subject to the Commission's scrutiny as ever. Having returned to Harvard Law School as dean, Landis had a personal perspective on the case. Referring to Sutherland's reference to the Star Chamber, Landis said that his outburst indicates that one is in a field where calm judicial temper has fled, reflecting a bit of the outrage that Frankfurter had expressed in a letter to Landis. The court's approach, Landis said, would have the effect, if not the purpose, of breeding distrust of the administrative. Still, Landis remained calm, perhaps to contrast his rhetoric with Sutherland's. He suggested that the courts were defensive because they understood that agencies had proliferated because of the court's inadequacies, and noted that the court's important cases were all divided and that the dissenters were likely to prevail in the long run. Because their reasoning seems more to accord with the temper of the times, he said, it is they rather than the majority who are likely to gain adherence to their position. The Jones case attracted a fair amount of attention in the newspapers, perhaps because of Jones' colorful personality. The New Deal's next confrontation with the Supreme Court, the last I want to talk about, made the front pages because Henry Wallace believed that the court had impugned his character in reversing a rate decision he personally had made. Again, this was a rate making involving this one, the Kansas City State stockyards. The relevant statute required that the Secretary of Agriculture give the regulated entity a full hearing. The question in the case was, what was a full hearing? The Supreme Court said that when the regulated entities alleged that the evidence, that basically the core was that the nominal decision maker, the Secretary of Agriculture, had actually not made the decision. The Supreme Court agreed. Hughes again wrote the opinion. He did set aside as fluff some of the objections. They could have had, and this is important again for the development of administrative law, they could have had a full hearing even if the hearing examiner had not prepared a report and let the parties see it before the secretary decided. That would have been good practice, but it wasn't essential to the validity of the hearing. Nor did it matter that acting secretaries heard the commission men's objections because they had merely heard arguments leaving the final decision to Wallace. Noting in passing that Wallace could have delegated the authority to set his rates to his subordinates, although he hadn't done so. Hughes endorsed administrative freedom to organize bureaucracies in ways that administrators found to be most effective. The heart of the problem, though, was that according to the allegations, Wallace had set the rates without having heard or read any of the evidence or even any of the briefs prepared by the commissionmen's lawyers, relying entirely on informal consultations with department employees. Now, if those allegations were true, Hughes wrote, the commissionmen, the regulated people, would not have had the full hearing the statute required. The hearing is a hearing of evidence and argument if the one who determines the facts which underlie the order has not considered evidence or arguments, it is manifest that the hearing has not been given. He concluded his opinion with the line, "The one who decides must hear." And the case was remanded to find out whether what had actually happened in the decision-making process. Consistent with Hughes' view about the modest effects of the ruling on the operation of a modern bureaucracy, Wallace and other New Dealers took the decision in stride. They believed that what they had done was entirely consistent with what Hughes had described. They were outraged, though, when Hughes, a year later, 2 years later, offered what major newspapers called a rebuke to Wallace when the case returned to the court. The problem began when the lawyers for the commissionmen investigated how Wallace had actually gone about making the decisions. Interrogatories showed that Wallace had indeed personally evaluated the evidence and made the decision. The one who decided had indeed heard. But they also revealed a catch-as-catch-can process of decision-making in the early years of the New Deal, and perhaps within any complex bureaucracy. Staff members, lawyers, and supervisors wandered the halls, had occasional conversations, dropped into office to discuss aspects of the record that had been developed, and produced documents that worked their ways into Wallace's hands. The staff lawyer in charge of the case for the Department of Agriculture compiled a set of proposed findings of fact and delivered them to Wallace, who said that he would read them at home, and he did. Wallace clearly believed that he had done all that Hughes said he should have done. But at the oral argument, the justices began to focus not on whether Wallace had read the evidence and made the decision. He, again, clearly had, but rather on how informal the deliberative process was. They probed whether the commissionmen's lawyer had seen the proposed findings of fact. They hadn't. Whether they had been given an opportunity to comment on the material Wallace received. No, they hadn't, and more. With those facts in hand, now Hughes concluded that the commissionmen hadn't had the full hearing that the statute required. Again, he adopted the standard progressive account of the administrative state's origins, the vast expansion of this field in response to the pressure of social needs. It had to be accompanied by adherence to the basic principle that in administrative proceedings of a quasi-judicial character, the liberty and property of the citizens shall be protected by the rudimentary requirements of fair play. And then he recited the facts in a rhetorically quite powerful way. No brief was at any time applied by the government. No opportunity was afforded to appellants for examining the record. Wallace didn't hear the oral argument. He dipped into the bulky record from time to time to get its drift. He read the briefs, had several conferences, and so on. For Hughes, a full hearing requires more than that. In a simple case, maybe the secretary could provide overhearing and make his findings on the spot, or receive proposed findings from both parties, each being notified of the proposals of the other. But it was a vital defect and not a mere irregularity that Wallace had adopted the findings prepared by the active prosecutors for the government after an ex-parte discussion with them. Hughes's opinion seemed to cast doubt on the kind of informal consultations within the bureaucracy that were almost inevitable, treating them as occasion in which sinister influences might be exerted, rather than as the way in which bureaucrats with different areas of expertise exchange information and work out solutions to complex problems. Hughes's approach would push in the direction of adopting court-like procedures at an interim, though important stage. But again, it's worth emphasizing, agencies wouldn't have to transform themselves into courts. Administrative action would be slowed by the adjustments required in this case, but the administrative state wouldn't be brought to a halt or even experience a dramatic decline in its ability to deal with social and economic change. The administrative state, had already been hobbled by the intrusion of judicial modes of action. Nobody could call a rate-making proceeding, as in Morgan, that began in 1930 and remained open in 1938, expeditious. Morgan made the situation worse, but only a bit worse. Now, to wrap up, I hope, the New Deal's defenders of the modern administrative state could count. They knew that they had lost all the important cases the Supreme Court decided. Landis leveled acerbic criticisms of the court. Others offered almost equally severe criticisms in more temperate terms. Yet for all the criticisms, the New Dealers seemed not to have appreciated how much ground they had gained. The court's major administrative law decisions were contemporaneous with the 1936-37 crisis in the court, and the court's decisions in administrative law mirrored those there. The New Dealers may have been distracted by some rhetorical flourishes in the court's opinion. They knew that the administrative agencies they'd created weren't the modern version of the Star Chamber. If the court so seriously misunderstood how agencies actually operated, they may have thought it could not possibly be sympathetic to the administrative state at all. But the New Dealers themselves may have misunderstood how things stood. They had argued that the modern administrative state required courts to withdraw almost entirely from supervising administrative agencies. Agency findings of fact, for example, should be completely binding on the courts. That aspiration was probably unrealistic in a world in which Dicey and ideals still had some purchase. Still, failing to obtain 100% of what they sought was not in itself a defeat. Each of the losses of the Supreme Court allowed incursions on even a rather weak version of Diceyism. The St. Joseph Stockyard case required the courts to defer substantially, although not completely, to agency fact findings. The Morgan cases allowed hearing examiners to adopt rather loose procedures, certainly looser than would have been tolerated from the ordinary courts. Defenders of the administrative state lost every case, but along the way they won a substantial amount. At the end of the 1930s, the administrative state emerged from the Supreme Court largely unscathed, and perhaps even strengthened. As the Supreme Court gradually accepted most of the progressive vision for administrative law, though, it chose to give up the self-denying ordinance. It chose to give up its ability to control the direction of administrative law's development. The parts of that forbearance that resulted from the constitutional transformation of 1937 were permanent. The parts that were pure administrative law, interpretations of the statutes establishing the agencies, were not. Congress could reverse the Hughes Court's abandonment of judicial control over administrative law, and eventually it did. But as of 1941, that outcome could only barely be seen. Thank you. Sure, absolutely. I mean, we've hit the time limit, and anybody can leave without embarrassment, but I'd be happy to take questions. Chris.
So, Mark, the view of the progressives that there could be such a thing as an aprofessional expert administrative process seems to us
Crazy.
either charmingly naive or delusional.
Yes.
So, what about maybe it's the water that people were drinking at the time, but what about the context in which they were operating made it possible for very intelligent people to have some obvious administrative mistakes?
At some level, I want to say this falls outside my period because this view developed in the late 19th century and early 20th century, but it is important to emphasize that Frankfurter and Scharfman thought that there was a scientific answer provided by economics to the question, what is a reasonable rate of return on investment? You know, this is crazy from an economic point of view, at least from a modern economic point of view, although economists in the late 19th century and early 20th century were offering what they said was a scientific analysis of reasonable rates of return. Similarly, in the area of criminal law, the sort of what we now think of and sometimes deride as root causes of crime thinking was prevalent. Judges and social workers could figure out what was causing crime by looking at social science, and we could develop institutions that would respond, that would deal in a scientific way with, it was implemented mostly in juvenile courts, with delinquent children. I think it was exuberance about the possibilities of science. The world had, economies had grown. The world had become a better place because of because of science, and that was where things happened. But mostly, I confess, I don't understand how they could have thought that a reasonable rate of return, you could use economics to come up with what a reasonable rate of return was.
I think we better end there. Thank you very much.